swear affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Afternoon, sir. State your name, please. Occupation? Thank you. And obviously co-counsel on this case, correct?
Yes.
You've been here for the testimony today regarding issues around certain discovery regarding Trayvon Martin's phone.
Certain factual matters, yes.
Brief over.
Yes, I don't
think the microphone.
Great,
Thank
thank you. A brief overview of the facts that bring us here today. If you would tell us when you first became aware of information resident on Mr. Martin's phone.
Summer of 2012, in that we saw the phone and realized it seemed to be operable and learned that there may be some information available from the SIM card at that point. Early August, I think.
And what was then the next information that we had gotten concerning any information from the cell phone?
I had made several requests to the state for whatever information existed, including any reports. And then I think it was late September, we had scheduled the deposition of the FDLE analyst. And I think it was that day, September 26th, I think, that we were given the report that the analyst had prepared in late March of 2012.
Had we gotten that report before September at his very deposition?
We'd never seen it before.
Moving forward then from September, when was the next time that we had any information or dialogue regarding additional information on the phone?
We were told at some point, and it may have been at the September deposition, that the internal memory, the flash memory, was not accessible, that the phone was locked out, and that efforts to obtain the passcode or the swipe code were unsuccessful. So there wasn't any information at that point that we could expect soon. We learned later in the fall, probably November, December, sometime around there, that the phone had been removed from FDLE custody and shipped to the Santa Barbara Sheriff's Office, I think. We learned all of that after the fact, and that the analyst there was able to ascertain the swipe code. And we made several requests and even, I think, filed some motions, and we finally got that information at the end of the year or maybe early this year.
Was there any additional information that was retrieved or forwarded to us from the California law enforcement agency?
We got a disk around that time frame, I think in late December, maybe January, that was represented to be a data file, but it wasn't of any value. We were told by the state and by FDLE that they weren't aware of any way to process that information into a report form that they had, or that whatever process they were considering would be so incredibly time-consuming that it was virtually impossible. And then at some point around that same time frame, we were told that the company Celebrite, the software designer to analyze these sorts of things, may be able, at that point, due to some developments in the technology, actually gain access to the internal memory.
At that point, then, had we filed motions in regard to trying and get a copy of the underlying data file?
Well, not to be sure that I understand, any underlying data file that existed at that point was either the SIM card, which didn't have much on it, or the data or the file that was retrieved from Santa Barbara, which we were told basically was of no use. We hadn't received any usable data from the phone.
At some point then, did you become aware that the phone had in fact been examined at Cellbrite?
Yes, we were in the loop on that. we knew that the FDLE analyst, Steve Brenton, was planning to take the phone to Cellbrite for an analysis to see if they could get their software to work. And we were told it would be a one-day thing. You could fly up, wait for the work to be done. They would know right away if it was going to be successful, and then return. And we were invited to attend if we could make the arrangements to do that.
And were we able to do that?
No. We were specifically told we couldn't participate, and it would be nothing more than simply standing there and watching.
At some point then, was that move or visit to Cellbrite successful as far as getting any additional information?
Yes.
And what was that?
I think Mr. Brenton went up there January 13th, 14th, somewhere around there. And we were provided, I think within that same week, by the end of the week, with a long report that was the Cellbrite analysis of the data from the flash memory, from the internal memory.
And do you recall the date then of that report?
January 14th, I think.
And to be clear now, is this now the second Cellbrite report that we had received?
This is a bit confusing. There was a short report prepared by the analyst in Santa Barbara, but all that related to, as I understand it, was getting the swipe code figured out. The report we got from Mr. Brenton in September related only to the SIM card, as I understood it, and that the report we got in January of this year was the big one. It was the big one from the internal memory. It was several hundred pages.
Do you now know that to be the report that was testified to earlier as being the 100 meg report as compared to the 3.5 meg report?
Yes, I think I've connected the dots on that.
As we now go forward, we're talking about the February 22nd report as being the same report that Mr. Krudbos testified to was the first report that he had seen?
Not exactly, sorry. We got the first report January 15th, roughly. And then near the end of February, around February 22nd, I believe, we got a second report from FDLE. And that was as a result of communication with the state attorney's office. When we got the report in January of 2013, it did not contain the source file or the bin file that we've been talking about here today. I made requests to the state attorney's office. That we wanted that. I made a specific request to FDLE by email and to Mr. Brenton. And Mr. Brenton responded to me that I needed to address matters of discovery with Mr. Delarionda. I talked with him in some fashion, but I know that by the end of that week, we got the second report, the one that we've been characterizing as February 22nd, 2013. At that same time, we also got the data file. The communication was, we're going to be going to court at the end of this week, and if we're not going to give it to us, then we want the judge to look into it. And by the time we got to the hearing, we had that information.
So we had actually had a hearing set to try and compel the underlying information that week. Is that correct?
I believe there were hearings set, and we wanted the court to address it then. Whether there was a specific motion filed, I don't know, but that was clearly an issue that was being discussed.
Now, there are two reports generated in early 2013, one by Cellbrite and the second one by FDLE. Was there any difference in those reports?
I think it's fair to say that Mr. Brenton generated both of them. I don't know if the first one was done at the physical location in New Jersey. I think it was. And then the February 22nd was generated by Mr. Brenton. The only differences that I'm aware of, and I learned this through Mr. Brenton's deposition on February 28th, was some formatting type things, that he may have added some cover pages or more personal reporting format, and that there were no significant data changes. It was basically the same report, just looked a little different.
The only changes were facial changes where it had the FDLE logo on the front pages and maybe in the corners of the report pages. Would that be accurate?
That's the way I took it, yes.
No substantive changes or additions to the data or deletions from the data, were there?
Nothing that was identified, no.
And you had mentioned that we had, in fact, set Mr. Brenton's deposition yet again on these issues.
Right.
And that was February 28th, correct?
Yes, I believe so.
Was the state present for that deposition?
Yes.
And without going into all the particulars, was Mr. Brenton questioned about work that he had done or information that was available through and up to date to February 28th, 2013?
Well, we were keying off of the February 22nd updated report, which really wasn't any different, as we were told, and that there was no additional information offered, that there had been any significant data recovered, nothing about new pictures or text messages that were previously unreported, nothing like that.
Moving then forward from that deposition, having concluded that, what was the next thing that you're aware of that dealt with any of the reports or information resident on Trayvon Martin's phone?
There was there was sort of a parallel track, if you will, in that on February 22nd, thereabouts, we got the source file or the bin file from FDLE. While the report was substantially the same, we were given no indication that there was new information available or that this report was updated other than by formatting. We did get the source file. So we contacted someone that we thought might be able to look at the source data to see what information was there.
Okay. And there was some testimony earlier about a text message and how that information was available for a deposition in March in Miami. Can you shed any light on the existence of that data?
The reference I heard to that today was some text messages about the acquisition or sale of a firearm. And I believe those text messages, at least, well, there's two conversations that I'm aware of. One relates to a .22 revolver, and one that relates to a .380. That's the reference in the text messages. I believe those text messages may actually have been within the initial report.
Now, did we at some point then learn from Mr. White that there may be concerns about whether or not the state had disclosed information to us that they had available from a download of the cell phone?
Yes.
And did we then decide to file what was then filed on May 23rd as a motion, on April 30th, let me back off once more, on April 25th, a motion for specific discovery demanding from the state all reports received from any source regarding Trayvon Martin's phone?
It wasn't limited to Mr. White, and I don't have a clear recollection of the initial conversations with Mr. White because I didn't participate in them. But I was personally present at some depositions in April in Miami where a witness testified that she thought some of the text messages were missing from the printout that I had shown her, which raised a question in my mind that I communicated to you. Maybe there's some additional information on the phone that we haven't been provided. And the consulting expert by then had told us he was able to recover some additional information from the phone that was not contained in any of the reports provided by Mr. De La Rionda's office.
And then did that lead as well to the April 25th filing of the demand for specific discovery?
Yes.
And was that then heard on April 30th?
I think so. That sounds about right.
And were you present in the courtroom when the court inquired of Mr. De La Rionda if he had received any reports from any source, from any person regarding anything having to do with Trayvon Martin's phone?
Yes, I think the inquiry was very specific. That included any information from anyone that hadn't been previously provided to the defense.
And what was his answer?
That they had not received any such information from anyone.
Did this then lead to the filing of our motion on May 23rd regarding the sanctions that bring us here today?
Yes.
Had we received the information in January, the end of January, beginning of February, when it was in the state attorney's office, how would that have assisted us in preparing for trial?
Well, first of all, we didn't get the source file until we made several requests for it. I heard the testimony today that Mr. Quidbus didn't have the source file immediately either, and he obtained it and then did his analysis and discovered all of this additional information, more than 1,000 pictures, I think he said, and deleted text and such by mid to late January, I would think. Well, it's hard to estimate how much time that would have saved us or how prejudiced we would be because we didn't know what we didn't know, and we took great steps to figure that out. And we still don't know, I don't think, because we've never received the report that Mr. Quidbus provided to Mr. De La Rionda that I know of.
And by that, are you speaking about the reports that were generated by Mr. Quidbus, both the underlying report and the additional Excel spreadsheet reports?
Right. I know that we spent a lot of time researching and investigating and hiring an expert to see if he could tell us what's wrong with this picture. And we're confident he came up with some of that information. We don't know yet whether he came up with all of it.
And what do you mean by that?
Well, once we got the source file, he was able to do an analysis. And through he's a licensed Cellebrite user, so he had the software. He did not have the same version that FDLE had. We don't know if he had the same version as the state attorney's office. There may be different versions that are licensed to government agencies as opposed to the private sector. But with the version he had, he was able to come up with a host of information, including photographs and text and ultimately additional information. So we began to digest that and try to figure out how it might relate to the case. But now we are into March, and we have depositions right around the corner, and we have only a couple of months at that point till trial. So we've just been absolutely overwhelmed.
Can you estimate for the court how many hours additional effort were then spent having to wade through all the information that had to be created that was not given to us by the state back in January?
If we had been provided the report the expanded report with the source file in January. We, I don't know, 50, 100 hours. It's almost incalculable because it was done over time through the efforts of many people trying to sort this out. We're looking for something sort of like the needle in the haystack.
And you've testified before about your hourly rate. Would you remind the court?
$350.
And my hourly rate?
$400. I yet don't know why that is.
Have we, to date, received anything else from the State Attorney's Office or from FDLE in regards to these updated reports?
Yes.
When was that?
Yes. June 4th, I think it was, 2 days ago.
And how large was that report?
In excess of 1,000 pages. And I know that it, as you may have heard the testimony, there are certain bookmarks on the report that identify different aspects of the report, so you can sort of match up the numbers of things. So you can match up the total number of images in the first report, for example, from the second report to then this report. And there are well in excess of 4,000 images, I think.
Have we had an opportunity before today to properly review any of those data on the new report in order to prepare both for trial and for response to any expert testimony that may be presented?
No, we've barely had a chance to scratch the surface on that. We just got it on the eve of this trial. I'm sorry, of this proceeding, which directly relates to that information.
And is this yet another basis for what will soon be filed as yet an additional motion to continue the trial set to begin in 4 days?
Yes, we still don't know completely what's on the phone. We haven't had a chance to review the report and analyze it further.
Do you believe with the time left between now and picking a jury starting Monday that you or I will have sufficient time to review that information, become properly capable to digest it, attend to it, and to get it to an expert to analyze?
And would you include the follow-up with investigation from information that might be in it? No.
The last comment, if you would expound on that. What do you mean by follow-up information?
Information that would then lead to further investigation, whether it would be locating and interviewing witnesses or consulting with an expert about the significance of it.
Such as if we had found a text message on there that said something about a gun purchase, we might have to look into the legitimacy and the foundation for that.
Certainly.
And there's another 1,000 or more images to still be reviewed in that regard?
Yeah, I don't have any expertise, so I don't know the significance of that even. I don't know if it's 1,000 new images or different renditions of old images or where all of that fits together. It's simply information that was effectively dumped on us 2 days ago that we don't have any ability to process at this point.
Nothing further on.
This consultant you hired, who was it?
Richard Conner, C-O-N-N-E-R.
And he was listed as a witness on when, sir?
Listed on a witness list.
Discovery. When was he listed as a witness?
I don't know the answer to that. Sometime in March, maybe early April.
I'm sorry, March or April?
I would think so.
And how many times have we contacted you or your office or Mr. O'Mara requesting a deposition of that witness?
I don't know the answer to that.
Would you agree that more than once?
Mr. Conner is on the list of people that you have coordinated with us for depositions, yes.
And to date, we have still to receive a report from Mr. Conner. Is that not true, sir?
No, I don't think that's completely accurate.
You've provided us a report of Mr. Conner, what he did?
Yes, in a way. And
Tell me where that report exists so I may find it.
sure. In our discovery, reciprocal discovery, It included reports that he prepared of some of the information on the phone. It was provided to you in several formats.
When was that? Because I'm not aware of us receiving a report from Mr. Connor regarding telephone, victim's telephone.
I'm not sure what your question is. We provided it to you as part of our reciprocal discovery. It was electronic.
When was that?
There's a notice in the court file of when the discovery was filed. I think it was probably in the last 2 or 3 weeks, but I don't know
I'm sorry,
precisely.
in the last 2 or 3 weeks that you did something? Is that what your statement is, that you provided us a report of Mr. Connor in the last 2 or 3 weeks? So you're saying in May you provided that to us?
Well, the report consisted of an analysis that's reduced to a PDF file or to an Excel spreadsheet that contains information. There were a number of those provided to the state as part of our reciprocal discovery. And I think whatever the date is that it was filed, and it was in the last 2 or 3 weeks.
In the last 2 or, and is there any reason why you waited until the last 2 or 3 weeks to provide that to us?
Not specifically. It was part of the ongoing discovery. We've been exchanging discovery.
Was it intentional, since you had hired this witness in March and he found some documents? Did you wait until now, the eve of trial, to disclose it?
Not for the purpose, I don't think, that you're suggesting.
Well, why did you wait so long to disclose it to the state?
The work was ongoing, and we had reason to believe that the state had information that it was withholding, and we were, frankly, spending a lot of the time that I was explaining here trying to get to the bottom of it and figure out what exactly your office had done. And I think we finally figured that out, and we filed our motion, and we consulted with our expert, and he confirmed that this information was on the phone. What we don't know yet is all of the information. Assuming for the moment it's in Mr. Brenton's report from 2 days ago, we haven't even had a chance to address that.
Yes, sir. My question specifically, do you recall what the title of, or the term that was used to describe Mr. Connor's report?
It wasn't.
Was it labeled?
It wasn't labeled specifically Mr. Connor's report.
Do you recall the phrase that was used to describe it?
To the best of my recollection, the electronic file folder that contained his work, that were the various reports that he prepared, including some Excel spreadsheets and some PDF files. It included some data that he had recovered that then turned out to be additional text messages and some Facebook and that sort of thing. I believe the folder that was provided to the state was labeled R. Connor, for Richard Connor.
Okay. And you believe that was 2 or 3 weeks ago?
Mr. Dillon.
No, I'm just asking if you don't remember, that's fine. I think you stated 2 or 3 weeks ago.
We had a couple of discovery disclosures. As you know, we've been bumping up against deadlines for quite some time now. And it was around the time that we filed a couple of discovery disclosures in the same week, if I'm not mistaken, or within a few days of each other. Some of them were some of the photos, for example. Some of them were text messages. And we provided your office with a copy of unredacted information.
Yes, sir. Do you believe it was in the defendant's second supplemental discovery or third supplemental discovery? Because I'm not seeing it. I apologize. Maybe it's right in front of me.
Can I have a moment with Ms. Count? Because he has it right here in front of him. Maybe I can
do
point
you
it
have
out to him.
Sure, I'd be glad to.
See these right here?
Yeah.
Under C.
Okay. So it's not titled Connor. It's titled Trayvon Martin Extraction Report, 10 pages. Trayvon Martin Extraction Report, 2 pages. I'm sorry, 1 page. 1 page, 4 pages, 1 page, 2 page. Is that what you're referring to? 1 page and 2 pages. Is that what you're referring to?
I can't say that I am referring to that specifically because I'm not looking at it, and
I'll be glad to show you if I may approach you.
I don't think I signed that particular document.
This is the one your co-counsel, Mr. O'Mara, said.
You know, I can't speak to that specifically, whether
So-
that's exactly it or not.
So by looking at it, even you can't say whether that is the document or not. Was that intentional on that part? You weren't trying to hide anything, were you?
We gave the electronic file to the state that had all of the information. That's a summary, and it's almost sort of a roadmap. You just look at the evidence. That's when we get CDs and photographs, we look at them. And
I apologize. I didn't see CDs in the discovery. I'm maybe-
talking about reciprocal, when your office provides us with CDs, we look at them. And when it's provided with photographs, we look at them.
So you're looking at the source, basically. You're looking at the source and then asking us to look through it to determine what's in there, basically. Right?
We provided, are we talking about information that Mr. Connor was
Yes, sir.
ultimately able to extract?
Right.
That was provided to the state in our supplemental
In
discovery.
a source, and then we had to look through it and determine what was there or not, right?
You just look at it. It's
Okay.
there.
Well, isn't it true that the source file regarding Mr. Trayvon Martin's phone was provided to you, I think you stated in February, January? Wasn't all that information there?
Here's what happened on that. We got the report in January. Mid-January, Mr. Brenton got back from Celebrate in New Jersey. And we did not get the source file.
You
And
got it
then
in February?
Then we asked for it, and we didn't get it. And then I wound up writing an email to Mr. Brenton, said, give us the source file, and he said, talk to Mr. De La Rianda.
Right.
I did.
And you ended up
then we
getting it in
got
February.
it.
Excuse me, I'm having a hard time hearing. Mr. O'Mara, can you pass notes?
I apologize, I was just trying to get him the discovery that he says he doesn't have, which was forwarded.
I just am asking if you have any information on what I know. Go ahead.
You got it in February at the latest, the source file?
We got the source file, and I believe the date is February 22nd.
Yes, sir.
Along with Mr. Brenton's second report that was substantially the same as the one in January.
Okay.
There were no significant differences. So we were not told, oh, by the way, we have all this other stuff that we found, all this other stuff that Mr. Brenton was going to be asked to provide. We got nothing. We got the same thing and the source file that was of no use to us whatsoever until we hired our own expert.
So your own expert actually found it there, right? It was in there. Your expert found it and you had received it in February. You're saying just you didn't know how to look for it until you hired your own expert, right?
After we got the source file, we hired an expert
Okay.
to take a look at it, and he did. And he started to find things that were not in the report.
Okay.
A lot of things.
Yes, sir.
And then we started wondering what's going on here.
But the evidence was in there, is the bottom line, in that source file, correct?
There is one source file, as I understand it. Some of the information is readily accessible, and some of it isn't.
Okay. You mentioned that you were aware, I think you corrected Mr. O'Mara, you were about the guns or the talk about guns in the initial report, correct?
That's my recollection. There were some text messages about guns in the first report.
So you had the actual data as early as February.
There was a picture of a gun, the description of the one, the hand on the gun on the bed. All of that was not, none of that was in the January report. None of it was in the February report that FDLE prepared. It wasn't until much later that was discovered. And in fact, we know from Mr. Quidbo's testimony, he discovered it in January.
You're saying that you did, when it was right in front of you, you didn't see it because you didn't know how to look it up. You or your expert didn't know how to look it up.
I'm not sure what you're asking me.
You hired an expert who is, I'm assuming, qualified to look this stuff up, right?
Mr. Connor is licensed with Cellbrite.
Right, he
And
knows how to
he-
work it from Celebrite, right?
He is licensed by Cellbrite, and he uses the most current version that's available to him as he explains it. Once we finally got the source file and gave it to him, he began an analysis, and that's when he started finding all this other stuff.
Right, and you consider what the information that Mr. Connor did for you all to be work product, correct?
We provided it to you in our discovery.
Did you provide the reports that he did?
Yes, that's what I was telling you that we gave you in discovery. Those are his reports.
This is what Mr. O'Mara says is the third supplemental discovery, which was done on May 23rd, which you don't know if it is or not because it's not clear, but Mr. O'Mara represented that it is, the one I just showed you.
If you will show me the electronic file, I'll identify for you what I'm talking about.
Okay. My question is, at some point, you guys decided to disclose it. You waited, 6 months to wait until disclosing it? Why did it take so long to disclose it to the state? And my question is, should we be asking for sanctions for you all for waiting until the last minute to disclose it to us? Well, you don't think it's a fair trial for both sides?
I'm not laughing because I think this is funny. This is far, far from amusing.
Let me ask you this.
We
sir.
caught you hiding the information and confronted you about it, and you never gave it to us. And we called a witness today to prove that you hid that information and then misrepresented it to the judge.
Sir, with all
That's
due respect,
okay?
Sir, with respect to the court, I'm not going to get into a banter back and forth, but I have Mr. Brett here who can explain everything, and he'll be testifying to refute your allegation because it's very good for us to make assertions or allegations without
Is
answering.
this a question, or are we in fact
I
answering?
apologize, Your Honor, I apologize.
Thank you, please ask the question.
My question is, sir, we have a pending motion to compel discovery where you refused your own expert, who you told, I'm assuming, or he stated not to write a report, sent you an email with documentation as to his findings, and you refused to turn it over to us in discovery because you said it was work product.
That's just not true.
You didn't have a dialogue with Mr. Manti and emails where he's requesting documents of your experts in terms of report. You said he didn't do a report, and you said it's work product because he just emailed me the information?
It's going to take me a minute to sort that out. Mr. Manti asked me for reports of experts that relate to the admissibility issue on voice identification.
Yes, sir.
That's an ongoing dialogue that we had, and I don't remember who filed the motion, but there's a motion on that issue, yes.
There's a motion to compel.
It has nothing to do with Mr. Connor that I can think of. That's why I'm having trouble understanding.
I apologize if I confused you. I didn't mean to imply Mr. Connor. I apologize if I misspoke as to that. My question is, we have been asking for documents from your experts, and you said all your experts, they don't do reports, right? Mr. Connor didn't do a report, did he? Did he do a formal report?
Mr. Connor prepared reports from his work on the phone. I guess you might call them extraction reports, and that we provided those.
Okay. Do you recall, I guess going back to Mr. Connor, when he prepared that report? Extraction report, whatever you want to call it. Would the date be on the extraction report?
It was never a single report that I understand. My insight into what he does and how he does it is somewhat limited. But once we got him the source file, he began to process it. And he got information that was previously unknown and began to tell us about some of that.
I guess
And that started in March.
Okay.
Yes.
And you guys waited 2 months to provide that to us? Is there a reason for that?
Yes, there's several reasons how all of that transpired.
Okay. My question, sir, is, as part of your obligations under discovery, you're supposed to respond within 15 days, 20 days. You haven't completely complied with that. Isn't that true?
No, we haven't complied in that, regrettably, discovery is still ongoing in this case to this day.
Right, and you do recall that the state filed a motion for you to comply, and then once the state filed a motion for you to comply is when you bombarded us with 2, 3, 4 reciprocal discovery finally. Do you recall that?
I'm sorry, I'm having a hard time connecting it with what we're talking about, but did we file reciprocal discovery? Yes, we did. We filed a good bit of it recently, yes.
And was that on purpose?
It was as a result of the ongoing process and some deadlines imposed by the court and late discovery by your office and, frankly, matters that are being litigated here today. It's all part of that, yes.
So it's a normal thing as part of the discovery for that to occur, is what you're saying?
I'm not saying that. I'm
Okay.
saying, if you're asking me to make a broad, sweeping statement like that.
Only
no.
in this case did it occur, you're saying?
It, meaning what?
Late discovery by the defense on the eve of trial.
No, I think discovery is ongoing, and it's not uncommon for there to be disclosures up until the point of trial. The problem then becomes, what do you do about it?
Okay.
And we got this information from you 2 days ago that we've barely cracked the lid on.
Okay, well, are you aware how that came about?
Not unless it's something other than what I heard here today.
Okay.
I heard what was said about it today.
Okay, then I'll leave it for Mr. Brennan to testify about it. I don't want to. So are you saying that when you're an employee of your office prepares a memorandum, that is not considered work product? When he reviews something and makes an analysis of it, that is not considered work product?
It may be partly work product. Some
Okay.
of it may not be work product if we choose to disclose the evidence because we want to call a witness at trial. We have a very different discovery obligation than the state. Ours is completely different. And I think that governs some of the discovery in this case and much of what we're talking about right now.
Okay. Thank you. I have no further questions, Your Honor.
Yes. The report, FDLE report that we received on February 22nd, 2013, who did that come from?
Who authored the report?
No? How did we get it?
You know, I'm not completely clear on that. I think it was handed to us, probably in electronic format, prior to a hearing that was scheduled later that day.
Did that come from the state attorney's office?
Yes.
And if what Mr. Krebo says is true, that was forwarded to us as a report from FDLE that was significantly inaccurate based on what Mr. Krudos testified to. Would that be correct?
Yes, substantially, significantly.
It was approximately a month before that Mr. De La Rianda had said to Mr. Krudbos, don't worry about it, FDLE will do another report. Is that the testimony that you heard?
Yes, that's the sequence.
There was a question of whether or not we had forwarded certain records or reports. I want to clear that up because it was I who authored the actual response. But in addition to the paper that you were shown, had we forwarded to the state a thumb drive that had upon it all of the reports referenced as extraction reports in that discovery?
Yes, the submission, the discovery exhibit, the pleading isn't the evidence. It's sort of a guide. It sort of identifies generally the actual physical product, if you will, or whether it's an interview transcript or photograph or a data extraction. And in this instance, all of the information was compiled on a thumb drive.
So we actually gave him the actual reports that our expert created, did we not?
the extraction reports, and then some,
Yes.
actually, a lot
We
more
did-
than just that.
We did not, as was suggested in his questions, say, here's some reports, go back to the bin file and find it yourself, did we?
No.
Aside, for example, aside from pushing the create report button on Cellbrite, has Mr. Brenton prepared any other report?
The last report I'm aware of that he prepared was a couple of days ago when we got it. And before that, the last one that I knew of was basically a reprint, and that was February 21st or 22nd.
How long are you aware of how long it took Mr. Connor to do his analysis on the bin file when it was finally received at the end of February?
No, I don't. I know he had a substantial investment of time, and I can't really estimate his hours. I'm confident it's in excess of 25, but I don't know how much more than that.
Nothing further, Your Honor.
Thank you, Lee Rudy.
No, Your Honor.
Thank you. Mr. Weston, you will continue to speak. Any other witnesses from
I'd like to call Mr. Delarianda, Your Honor.
Mr. Delaware?
No, I'm not going to subject myself to it. I don't think it's a problem.
I have-
I'm going to object to it.
We have two matters here, Your Honor. One,
Let me just say this as an aside. The court's intention for setting aside today and tomorrow was to conduct a Friday hearing over expert testimony. It is now 2:27 and we have yet to get to that hearing. What the defense is seeking in this motion we've been hearing since 9 a.m. is for monetary sanctions, which are easily taken up post-trial. The documents you already have, and in your motion and the testimony of Mr. West, you're seeking monetary damages. I think that the court's time on this issue is better taken up, as I said, post-trial, and that we need to get on to the Fry hearing. Because at this rate, we won't get that completed before we start the trial on Monday, and it's this court's intention to do so. So I am going to suspend the rest of this hearing until post-trial, and I would like to start the Fry hearing. Do you need a few minutes to get ready to get your experts online to do that?
may I respond, Your Honor?
Of course.
We are seeking not only the monetary damages, but I believe that you should inquire as to Mr. Delarianda for this purpose. If in fact, and I think the evidence is certainly clear enough for the inquiry, and our request, our motion, was not just for sanctions, it was for judicial inquiry. Because if in fact Mr. Delarianda sat here and said what he said to you a couple of weeks ago, and you interpret that to be an untruth, then that's direct criminal contempt.
Okay, and that can be done post-trial also, is my point. You're not seeking to have a witness excluded from testifying. You're not seeking to have evidence excluded. So those other sanctions that you're requesting can be done post-trial. And I think, again, the court's time is better used at this juncture going forward with the Fry hearing. My understanding is that there are several expert witnesses who are waiting to testify, and I would like to begin with that. So I will give you a 10-minute recess, and let's get those witnesses up. The court will continue this hearing post-trial. Court is in recess.